Good evening, everybody, and thank you for joining this live webinar from the Tenant Farm Association, brought to you from head office tonight, seeing as it's the last one before the summer break, where we're excited to welcome Julie Robinson, Head of Agriculture at Roythorn Solicitors, as our guest speaker this evening. My name is Robert Martin, and I'm the National Chairman for the TFA. And this event is kindly sponsored by Roythorns. So we have a double plug tonight. Roythorns have kindly agreed to sponsor the next 12 months of TFA virtual events, as well as other TFA digital knowledge share content. Roythorns is a national law firm steeped in agriculture. They have 90 years experience advising landowners and tenants alike. Their lawyers are active in farm tenancy policy groups. They get the big picture. So whether it's a succession application under the AHA or a new farm business tenancy, a dispute with landlords, or share farm agreement, or a collaborative natural capital agreement, Roythorns is there to advise and assist. Tonight's webinar will be recorded, and once edited, will be available on the TFA YouTube channel. To find our channel, go on YouTube and search for @Tenant Farmers. Our video library features all our past virtual events, knowledge share, teachings, and key news snippets. We encourage you to pay a visit and subscribe to our channel, so you'll be notified when we upload new content. Previous webinars include our regular DEFRA ELMS and SFI updates, the Dartmoor review conclusions and impact on other protected sites, and diving deeper into soil carbon issues. So moving on to this evening, here's a little about our speakers. Julie is a lawyer specialised in agriculture tenancy matters and sees thriving tenant farmers as critical to the success of the whole sector. Her baptism to the specialism was serving as a secretary to the NFU Tenants Committee 2001 through to 2003. She went on to be the NFU's chief legal advisor and continued to be heavily involved in landlord tenant matters. Julie's been acting for farmers in private practice at Roythorns since 2012, with a break in 22 to 23 when she worked in the National Trust legal team. Among other roles in agricultural policy groups over the years, she is now the Agricultural Law Association representative on the Farm Tenancy Forum, set up following the ROC review to support the implementation of the government's response to the review's recommendations. Following a short presentation from Julie, we will hold an interactive question and answer session. This will give you a chance to ask questions to the panelists live. Alongside Julie, we have Mr. George Dunn, Chief Executive of the TFA. For those who don't know George, he's been the Chief Executive of the TFA for the last 27 years. Previously, he worked for the Ministry of Agriculture, Fisheries and Foods in Whitehall, London, and in the Country Land Association head office. George has represented the TFA on the Tenancy Forum Industry Group, was a member of the Tenancy Working Group in England. He's also represented the TFA Cymru in the Welsh Government Strategic Framework Partnership. Most recently, he's been invited to be a member of the Tenancy Working Group in Wales. So I think we will hopefully hear from both our people when we come to question answers. We are going to have a live question answer. So if you can put any questions that you think need to be raised in the question answer area in the bottom of the screen, please do so. And I think what we will do is we will kick off the first part of our presentation, and that's from Julie. So I'm going to hand over to you, Julie, please.
That's great. Thank you, Robert, and thanks to everyone for tuning in this evening. And I'm very glad there wasn't a certain semi-final on this evening. Otherwise, we'd have been talking to ourselves, Robert. But
Absolutely.
And just want to say thank you to Julia Meadows, who's behind the scenes and will be changing and switching my slides for me. So let's dive in, folks. The first thing I want to say, though, is that in private practice, I act for both landlords and tenants, so I see things from both sides. But basically, a lot of what I'm talking about this evening and going to be answering questions on, I hope, is what's on my desk. I mean, it's what I'm doing and what I've been doing for the last couple of years, particularly since the emergence of that word, that term, natural capital, etc., and that explosion in renewables. As well. Now, it does get a bit technical, but that's inevitable, and that's what you get if you invite a lawyer to answer the question, which we'll now dive into, what to do when your landlord wants land back for non-agricultural use. Now, I'm making an assumption that we kind of have in mind what we think of as agriculture and what we think of as non-agricultural use. That is one of the technical questions, but for now, let's just go with a common understanding of what we think is non-agricultural use anyway. What we certainly know is that it's something that landlord may want land back for and may have a right to have land back for. Anyway, step one, and this is it, probably before you spend money on lawyers, but it might be with the help of an agent. And it's very much to find out as much as you can once you get an inkling, either from the landlord or his agent, or even just from, you know, what's being heard around the estate or in the local press. Find out as much as you can. Landlord's intended timelines, what kind of use, what is it that the landlord wants to do with all or some of your land. And then really, I think, again, before you spend a lot of money on people like me, you probably want to start thinking about the potential impacts on the farming business, on your livelihood, on the family, and succession and the long-term future on that land. And the other thing you want to maybe just try and sort of push on a little bit is whether there's some kind of deal on offer. And I say that because I have done quite a lot of surrenders where tenants, for one reason or another, had no successors, were edging towards their own retirement. There was the lump sum exit, in particular, that payment was available as an added sort of thought in their mind. And actually, you know, obviously that lump sum exit payment helped pay their lawyers' fees in negotiating surrenders and sorting it all out. But they were, you know, some of my clients were proactive. You know, they actually sort of went and pushed at the door a little bit because it was a moment where there was some added benefit to them in doing something that maybe a couple of years down the road they would have been looking to do anyway. So that's why I sort of stress that at the beginning, really. And the other point, and which ties in with that, is very much to bottom out what you want. And, you know, are you ready for retirement? Do you have somebody on the farm who's raring to take over from you? And there is a future farm business, there is a succession on offer. Would you be able to do a deal? Or do you want to be involved in the non-agricultural use? So if it's solar panels, do you want to be involved in maintaining that land, grazing under it or whatever? So these are questions which will all inform the way things develop and the conversations with the landlord, or at least the landlord's agent. Now we get to the bit where, in a sense, the lawyers are involved, and you need to spend some time doing this, or at least getting your lawyers or agents to do it and report back to you. But you want to check your tenancy agreement, particularly if you haven't got a written tenancy agreement. Whatever you do, just come and see me. All right, because we need a written tenancy agreement. Okay, but let's just check your tenancy agreement. Check your permitted use, because that can impact on how likely it is that the tribunal will uphold a landlord's general notice to quit. It can impact on many elements of the discussion that go on. Whether your permitted user is dairy farm only, whether it's agriculture and conservation, it's some of the larger estates maybe, or the institutional landlords. Check your reservations, because the landlord may not need to take land back. He may have a right to do certain things on your land. And there may not be much you can do about it. Check for short notice, notice to quit part. These are technical things, but we want to check them out and understand your statutory rights. What is it that the Act says landlord needs to do, you have a right to do, a tribunal must do, what must go to arbitration, etc. And then the last thing on the legal point is have a look at case law. Who's been there before you? Who's already, been through it, and the court has made, the court, or indeed the tribunal or first tier tribunal in some cases, has made decisions which might be useful to you, or indeed inform you that actually you're on a sticky wicket using a particular argument. Then I would say, subject to what I said right at the beginning about finding out sort of a little bit of what's going on, is to seek advice early, and certainly don't start making any commitments to landlord or saying you won't object to planning permission applications or whatever without taking advice. Advice is going to be an agent, it's going to probably be a lawyer at some point. And then obviously, and always, we have some very good examples of this in recent times. Start a campaign. If there's a policy issue involved, start a campaign. We see that the Sturdies did a great job in Old Malton, and we can see that there's been some some campaigns about tree planting in Wales. So that is always there. The other thing to bear in mind, you'll just see that little yellow box in the bottom there, is there is a new tenant farming code of practice, and a lot of organisations and professional advisors have signed up to it. And the basic principles are clarity, and that's partly why these discussions need to happen, and they need to happen in a sort of as honest and open way as possible. No secrets, notices to quit sort of sent between other ones in a great wad of notices or whatever. So clarity and communication, and then in some cases, collaboration, and there may be opportunity for collaboration in this. Julia, I wonder if you could stop slide sharing for a moment. So one of the things I just want to say about this whole topic is it is a very policy related topic, which is why the TFA is so involved. But it's not just the TFA, because if you think about the policy issues that are involved in this, and legal is just one tiny little bit in it, and your life is also just one tiny bit in it, even though for you it's the biggest thing. But in terms of policy issues, we've got the tenanted sector in agriculture following the Rock Review. We've got planning policy. Massive kind of focus on that, massive focus on planning policy and land use. What should we be using our land for? And that is very much all of these notices from landlords and these changes of use on tenanted holdings come into the wider debate about what should land be used for. We've got climate change, we've got that need to sequester carbon. And you can see that we've got the housing push, and so you can see that there are lots of policy areas that influence how people feel about planning applications, how people feel about applications by landlords to take land back for non-agricultural use, and how fair and reasonable a landlord might appear to be. So that's the first thing to say. This is a policy area. The second thing to say is, and most of my time, I don't spend time doing the law. I spend time sort of doing and working with people and relationships and deals. And so really, once again, it's about you and what you want, and it's about what you can live with, what you need, that very much must influence the way you respond to your landlords in these situations. And only really thirdly do we come to the legals. And really, I think of the legals in this situation not as what we go front we hold up in front in our approaches to landlords, but as the backstop, that we need to understand what does case law say, that, if the worst comes to the worst, or are we on a strong wicket here? So it's the backstop from which we then go into our negotiations, or indeed make our representations, etc. So if you just bear that in mind, we're now going to have a look at the legals, and hold on to your hats. It's a bit technical. I love it, obviously, but hold on to your hats, and then that will then influence some of the answers to what I hope are lots of questions from you on this. So Julia, if you could put it up. The slide, please. We're going to have a look at, I mentioned, look at your tenancy agreements and look at the reservations. And when I first saw this reservation in a tenancy agreement, oh my goodness me, what on earth is this? Never. And then I saw two more tenancy agreements that had a very, very similar reservation in. And some of you will recognise the first part as it's a landlord's exception of the trees on the holding. That's, we kind of nod, yeah, landlord trees belong to landlord, etc., etc. We mustn't damage them as tenants, etc. So all lime, other trees, pollards, saplings, underwood, now growing, or which shall grow on the holding, with liberty for the landlord and all persons authorised it to enter upon the holding in order to mark, fell, cut, and carry away the same. All familiar so far. And then we get the right for the landlord to plant and replant any part of the holding, and to cart the same is lawyer speak for trees and timber, over roadways, etc., and without making any payment to the tenant for the use thereof, but making reasonable compensation to the tenant for any damage done in the exercise of the rights. Now, look, this is really quite interesting, because if your landlord decides to do a large tree planting scheme to maybe under a woodland grant, or to sequester carbon under a private scheme, and that is in your tenancy agreement, we're going to have a bit of a debate about it. Now, we'll have a look at reservations, I think, in one of the questions that has come up. But there is a point at which you could say, hang on a minute, that's an absolute nonsense, because you can't sort of let it to me to farm on the one hand, and then say you can plant trees over the whole holding. That would be what we might call a derogation from grant. But actually, this reservation is the bargain between the landlord and tenant. And I'm sure there's a point where we would argue it would be unreasonable, but it's quite a difficult one, this one, to contend with. So, Julia, could I have the next slide, and let's have a look at another reservation. So this reservation is a newer reservation using these buzzwords like natural capital. And you'll find it, I've found it, and in farm business tenancies, newish farm business tenancies, and in succession tenancies. So where this gets put into the landlord's reservations. So here we go. It's the right for the landlord to enter into a natural capital scheme in respect of any part of the holding, including in particular the carbon storage and sequestration potential of the soil, subject to the landlord being eligible to make use of the land under the tenancy, and subject to exercising this right not materially and adversely impacting on the routine farming operations of the tenant or any agri-environment scheme entered into by the tenant. Now, I tend to be less concerned. I don't like it when I'm acting for tenant. I don't like it. I tend to be a bit less concerned, because there is this sort of constraint on it not affecting the routine farming operations of the tenant, and it's quite difficult to see in some cases that natural capital and even carbon sequestration, even under pasture land, doesn't impact in some way on the routine farming operations of the tenant, or cross over with agri-environment schemes. I think what it is it's landlords going, is this agriculture? Is natural capital? So carbon, if we take carbon sequestration and the sale of carbon units, 1 ton of carbon equivalent, if we take that sale of carbon units, is that agriculture? And I've had quite a lot of debates with colleagues on this. And I think the consensus is that that itself is not an agricultural activity. It comes back to permitted use for agricultural purposes only. Sale of a crop of corn or of lamb is the produce from agriculture. But sale of an offset to another business to offset their carbon emissions is not in the same thing. So it's not, I think there's a strong argument this isn't agriculture. So what landlords have done, or their advisors have thought, okay, let's try and capture, again, just as we do with mines and minerals and timber, let's try and capture non-agriculture and say that we have the right to that. So I'm not, some of these clauses are quite restricted, but this particular one, because of the conditions under, in the latter part of the clause, I'm not too concerned about. Let's have a look at the next slide, Julia, and we're going to talk about case B. And there's not many places in the country I could be where I talk about case B and nobody has a puzzled look on their face. But probably a TFA seminar is one where people just nod and go, "Oh, case B," the dreaded case B. So in theory, this incontestable notice to quit a holding because the land is required. So the land is required for a use other than agriculture. Now, of course, the first thing I would do, the first thing a lawyer would do is go, okay, so what's agriculture? Well, then we go and have a look at the Act and see what the definition of agriculture is, and we get what is pretty familiar, coming through from the 1947 Agriculture Act, basically, but we're quite familiar with it. Dairy farming, seed growing, use of the land for horticulture, meadowland, use of the land for grazing, livestock, rearing and keeping, osier land, and woodland where it's ancillary to the farming use, so things like shelter belts, etc. So we kind of have that, we do have a technical definition of agriculture. So we're going to obviously put any case B, we're going to look and see whether natural capital has elements of agriculture in it. And, obviously, there's going to be a big question mark over that. So let's carry on with what case B involves. So it's not just land other than for agricultural use. It's for which planning permission has been granted under Planning Acts or by a general development order that has been approved by both houses of Parliament. And I remember, just coming to case law, the Kirby case in 2020, I think the TFA were involved in that, where a case B was successfully challenged because the general permitted development order of 2015 hadn't, it turned out, it wasn't one that had been through the approval of both houses of Parliament. And so it was refused by the arbitrator there. I think that was the arbitrator. So we've got planning permission under the Planning Acts, we've got general development orders, and then we've got other provisions in non-planning acts which deem permission under the Planning Acts to have been granted. A prize for anyone who finds anything relevant there. I have looked at certain points to see whether there is anything of use, but I haven't been able to find anything. I'm sure there is something buried in other acts and obscure acts. So the question really, I think, is this land required for a use other than agriculture, which needs planning permission? Now, very little of the natural capital projects need planning permission, in the sense that a lot of it has a very, it almost has a sort of, falls into a kind of agriculture or an already something that is deemed not to be development. So the question really is, if our landlords can't use case B to get land back for natural capital, and I'm trying to think of, I'm trying to think of a couple of instances where it might be used. One is obviously constructed wetlands for nutrient neutrality, because those are engineering operations. The question really is how much is actually sort of engineered and how much is actually reversion of arable land to pasture that we might call agriculture anyway, within that planning application, but where planning application is needed for a constructed wetland. The other one may just be, and this is something that is coming up and is being talked about between with colleagues, is where we have a red line housing development on land. And I've seen one of these in practice where we've got the red line housing, there's a sort of brook, and then on the other side, there's going to be meadowland created with some sort of walkways over from the housing to that meadowland. And that meadowland is going to serve as the biodiversity net gain area to unlock the development. So the development will, will be houses, pretty much wall to wall, so to speak. And then there'll be meadowland. And if the developer puts that all within the red line of the development, the question really is whether that will get through under a Case B application and allow the landlord to serve a Case B notice to quit. Now, personally, I'd quite like to have a go at that. I think that would be worth thinking about whether, there's some chance to challenge that. Because if you think about it, we come back to permitted user, and you say, well, actually, my use of this holding is agriculture. Meadowland falls in the definition of agriculture. That's me. That's the tenant. I should be doing that meadowland. So it doesn't need to be taken out of the holding. So worth thinking about that one. Next slide, please, Julia. So if the landlord can't get land back under a Case B, incontestable notice to quit, obviously it can be challenged by arbitration to ensure that the landlord has made out his case. But if the landlord can't do that, then the landlord is left trying to serve a general, or what we might call an unqualified notice to quit. Now, let's just have a look at what the conditions of that are. So Section 25 of the Agricultural Holdings Act, for those who like the legal reference, a minimum of 12 months notice from the end of the current year of the tenancy. And this is where we need to be on our guard and get to work quickly once we've received these notices. If the tenant serves a counter notice within 1 month, then the notice to quit doesn't take effect unless the tribunal, on the application of the landlord, so that he then has to make an application within another month, unless the tribunal gives consent. Just one little point here, and it's about notice periods. So generally, there's a minimum of 12 months notice, ending at the end of a year of the tenancy. But an exception to that is where there's resumption of a holding or part of it for a specified purpose. So landlord has to say it is for this purpose in his application to the tribunal. And the notice is given in pursuance, that's legalese, of a provision in the tenancy agreement that says he can give short notice. Now, it can't be too short notice, but it's usually, typically tenancies will have 3 months, they might have 2 months notice. So watch for too short notice, because tenants need time to claim compensation before termination. So too short, the provision in the tenancy would be void. So landlord does have the possibility of serving quite a short notice. But again, we come back to that question really, which is what is non-agricultural use? And we come back to the definition of agriculture. And I think, Julia, could you put the next slide up, please? So here we go. So the tribunal must be satisfied on one or more of, and forget the other ones because we're not talking about them, but underlined, they must be satisfied that the uses other than agriculture not falling within Case B. So it's got to be non-agricultural use and not falling within Case B. Now, and the landlord has to state that use. So we have a case again. I think it was TFA commented on it a couple of years ago. Case called Bayliss against Herefordshire County Council, and they served a general notice to quit instead of a case B notice. And it was land that there was an application for housing on the land, and in fact, planning permission was granted while the case was going through its tribunal proceedings. And the tribunal were very clear that actually it wasn't right to serve a general notice to quit because although planning consent hadn't been granted at the time, it needed to be granted for that non-agricultural use. And so the application had to be on a case B basis. Now, even if landlord can make out that the use is not agricultural, and this is a big question, and it's untested. It's untested, and probably every lawyer in the land would love to be the one that runs the test case on this, depending which side they're acting for, but probably on either side, is whether conservation, for example, whether rewilding can cross a line where it becomes non-agricultural. It's a difficult one because a lot of rewilding appears to involve some grazing. It may even involve, it certainly will involve some livestock. It may involve some livestock rearing. It's a difficult one, but I think this case will happen where the landlord may try to recover land for something that the landlord says is non-agricultural, and that is a hotly contested issue and becomes a case that we all watch. But even if the landlord makes out his case, this is why I love this general notice to quit provision, even if the landlord has made out his case, the tribunal shall, that means they must withhold consent if in all the circumstances that's the people's side of things, that's the people's side of the landlord's mission, the landlord's intention, that's climate change, that's policy, there's a lot of things in that mix, all the circumstances. It appears to them, if it appears to the tribunal that a fair and reasonable landlord would not insist on possession, then the consent to that notice to quit has to be withheld. So once again, we come back to the permitted user. And if the landlord is going to be doing something which has a feel of kind of growing stuff or managing grazing or or planting trees, bushes, hedgerows, whatever, I think the tenant might say, hang on a minute, that's me, that's my job. So you don't need it back for that to happen. Let's talk about it, do something different. Next slide, please, Julia. So very quickly, technically, and then I'm really quick. The other thing is that a lot of the time, landlord doesn't need your whole holding. He only needs part of it for his development or non-agricultural project. And it's always a moot point whether the landlord has a right to serve a notice to quit part. So he either needs something in the tenancy agreement. A lot of them have it. A lot of the older tenancy agreements and newer ones have it. Or landlord needs to use section 31, which is for specified public good purposes, such as tree planting. That's the classic non-agricultural use, tree planting, reservoirs, roads, etc. That unqualified notice to quit part, that's still subject to the usual notice periods and the right of the tenant to object on that. So, folks, I think we'll just cut there and go to a Q&A, and we can maybe cover farm business tenancies in the Q&A. So thank you, Julia.
Well, that's fantastic, Julie. It's been a whistle-stop tour through everything that we need to know about Case B, and I know I've learned quite a lot tonight already. So it's the opportunity for everybody to ask questions now or give feedback, and you can do that by putting your questions in the question answer area at the bottom of the screen. We also had quite a number of questions in advance of tonight as well, and I'll lead off with this one for you, Julie, if I can, please. If planning permission for a solar development on HA land was granted on the basis that it is the land that would still be grazed, would case B notice still be valid if it was issued?
Yeah, so this is the question from Cheshire. Right. I would love to give a different answer to this question, okay? Right. This is about, I think, this is in case B, it is why has the landlord served a notice? What is the primary purpose of that, of his serving a notice? And he hasn't served a notice in order to be able to graze. He's served a notice in order to be able to put up a massive, well, it needn't necessarily be massive, but to put up solar panels in the field, maybe battery storage, etc., etc. So the key case on this is a case called Floyd Ackland against Osmond. I think it's 2000, so 25 years ago now. But basically, the court really did lean on the side of the landlord here and said there can be some subsidiary, even some concurrent agricultural use. But the question is, what is the purpose of that development? This is in Floyd Ackland, it was a minerals development, and the land was going to be restored to agriculture afterwards. And the tenant argued that, well, hang on a minute, this is agricultural use in the end. But the court, I'm afraid, went with the landlord on this and said, no, let's think about case B. It's about something that needs planning permission, and there can still be an element of agricultural use in that. So I think that's, but personally, I think that's quite a tough one. I think as well, Robert, I think we've got another question about solar panels from Oxfordshire as well. Yeah, I can see in the questions.
We do, and it's very similar to what the first one was there, actually, yes.
So can I answer that question? Because the thing about your landlord even mentioning in a whole series of planning application documents that there can be grazing under the solar panels, I think cuts both ways. So I think it needs some careful thought, as any objections, any framing of challenges to planning applications. But I think it cuts both ways, because the developer can argue, well, I know there's a strong argument about food security, but actually this is still providing food for sheep or for grazing animals. And so we're not losing total sort of food production from this land. And the developer or the applicant can also argue that there is an opportunity for some income for the tenant who's being displaced by looking after that, either the grazing or the maintenance of the land. So I do think it sort of cuts both ways, that point. And we can see it in, there's a Wiltshire case which has just been published, a Wiltshire appeal. And that was really what was debated within it. Was the continued use of the land for grazing, and it simply didn't touch upon whether a case B notice could be served or not.
You want to come on at this point, George?
Yeah, thanks, Robert, and Julie, thanks so much for your tour de force in your presentation earlier. But I am going to slightly disagree with you on this one, and maybe we get a bit of debate about it. I think the case that you referred to, yes, it was a minerals case where the land was being temporarily removed from agricultural use for a period of time and then reinstated as agriculture at the end of that period. Yep. And what the court said was it is a use other than for agriculture for a long period of time. The fact that it comes back to agriculture is immaterial. I think there's a difference if a planning consent has been granted on the condition that there is a continual agricultural use of that land. And I think it is still arguable that in not extinguishing the agricultural use for any time, the landlord is not entitled to a case B notice to quit, because the consent can only be operated if the landlord continues to have an agricultural use of the holding. So that's where I think we would still have an argument in relation to case B, yeah. And we see this a lot where local planning authorities grant consent for solar energy on the basis that there is grazing.
I certainly think, George, that may be stronger grounds if we're relying on a clause in the contract of tenancy rather than the statute in this case, where I think the statute, the Case B provisions in the Agricultural Holdings Act, I don't disagree with you, actually. I mean, of course, there's a distinction between that sort of temporary use. But what's clear is that planning consent is needed for that solar farm. That the fact that there is continued grazing is not the primary purpose and is not what drives whether there needs to be a planning permission. The fact that it's development is what drives whether there needs to be planning permission. But if landlord's relying on a contract in the tenancy, which says the landlord says short notice to take back part for non-agricultural use, then I think tenant has a bit more leeway to argue that, hang on a minute, agricultural use is continuing.
But in the sense that you need planning consent for certain agricultural buildings, it's not the fact that you've got planning consent for that building that gives you access to the Case B. It's because the use is for other than for agriculture. So it's got to be other than for agriculture. And if part of your consent is agricultural, I think you're vulnerable as a landlord. But we could talk about that all night, Julie.
That's right. But I just want to say the one where I think there is a case to be argued is the one where the biodiversity net gain land is thrown into the red line with the housing development on one side of the brook and the biodiversity net gain land on the other. And I think that is, I think that's worth really thinking about a challenge on that one, on the biodiversity net gain land. But if it can't be done under Case B, we then go back to the general notice to quit. And the question is whether the landlord is being reasonable and fair, given that it's a condition of the planning permission that biodiversity is enhanced. And that's where we hit the policy debate, really, and the tribunal will be influenced by that too.
Goodness me, I do like a back and forwards. It'd be like watching Wimbledon, this one. Goodness me. So we have another question here for you, Julie, as well. A member from Wiltshire. As part of the landlord's application for a development, they need to carry out an archaeological survey, and they will require to excavate some plots on the holding. Do they have the right to do that?
Yeah. It's so I'm not quite sure whether this is an agricultural holdings act tenancy or a farm business tenancy, but it doesn't really matter because it comes down to the reservations. So what was the bargain between landlord and tenant about what the landlord had the right to carry on doing on the holding after letting it for agriculture? And again, generally speaking, there was a case a couple of years ago called Rees, where the tenant objected to the landlord doing exactly that kind of thing, bat boxes, leaving them out to monitor, doing surveys, etc. And again, the court was really, I think, this bigger policy issue about needing development, etc., that's taken into account. But that it's a question of extent. It's a question of fact and extent, really. If something is intrusive and starts stopping the tenant doing what he's been granted the tenancy to do, then it's one thing. If it's and I would look at something like archaeological surveys and digging plots. I would certainly have a serious look at that and see whether the landlord has the right to do it, and if he doesn't, actually sort of probably make some kind of fuss. That's a legal term.
Okay, well, thanks for that. We have a question for George here from a member from Cumbria. Is anyone looking at changing the statutory basis for compensation for loss of land under a Case B notice to quit? I think you're on mute, George.
Sorry, I'll start again.
Thank you.
For information, the statutory basis upon which a tenant is able to claim compensation if they lose land with a landlord using a Case B notice to quit is a maximum of 6 times the rent passing for the proportion of the land and holding being taken. Now, anything else can be negotiated. So you can negotiate a higher level of compensation. And as Julie was saying, that might be possible in certain circumstances. But if the landlord chooses to rely upon the statutory provisions, it is 6 times the rent passing, which we have always said, or for a long time been saying, it comes nowhere near in the vast majority of cases of dealing with the tenant's real loss in those situations. It was a matter that was considered as part of the ROC review into agricultural tenancies, and one of the recommendations was that the government should look to change the basis upon which compensation is payable, and we would certainly be arguing that the compensation should be based on what is the tenant's real loss, because what you want to be doing is putting the tenant back into a financial position that they would otherwise have been in had they not lost the land to the case being noticed. So the short answer is yes, but the long answer is it was not one of the recommendations that the last government decided to take forward from the ROC review, but it may be something that the current administration would be prepared to take forward, given that we are aware that the current government, when it was in opposition, agreed to all of the recommendations in the ROC review.
Okay, well, thank you for that.
Yeah, and for sure, George, I imagine the TFA will be raising that point if it hasn't already. I will just say that if when I and colleagues are advising landlords, we find that basically landlords, particularly where there's a development and they're entering into a promotion agreement with the developer or whatever, but actually the developer wants to know he can get stuff back. He's got his timeline. He absolutely needs to be, otherwise he's buggered really on the whole thing if he can't get the land that he needs to build his development on. So he usually, it just makes sense really that he's usually willing to I want to say throw quite a bit at that, but he's usually willing to pay quite a premium to get that certainty. I'm not saying, George, that there aren't times where you will get an absolute, a notice to quit under case B, and you'll get that minimum level of compensation. But I think I probably agree with you, raising that level.
Okay, well, that's good. We have another one here for you, Julie. I have an FBT. And my landlord wants to take some land away for tree planting. Is he able to do so?
So again, what we're going to do is have a look at the tenancy agreement, one, and then we're going to have a look at what the statute says in terms of notices. All right, so oddly enough, farm business tenancies are more restrictive in terms of notice periods than the Agricultural Holdings Act tenancy, at least in certain respects. So if you've got an FBT which is more than 2 years, then the landlord needs to give you a minimum of 12, that is more than 2 years fixed term, a minimum of 12 months notice. And if you've got an FBT that's rolling on from year to year, that notice has to end, at the end of a year anniversary of a term date. So one is notice periods, but can he do it? Well, it really depends whether the bargain that the tenant has agreed with the landlord allows the landlord to serve notice to take land back for non-agricultural use. And it may even, because I've seen them now as well, which do just specify tree planting. So they're not saying no non-agricultural use, they're saying for tree planting, for schemes, etc., within, on the carbon sequestration side. So I'm afraid it may well be that the landlord does have that right, because that's what's agreed in the tenancy agreement.
I suppose a supplementary to that question is, would it be different on an HA tenancy?
Well, it would, because we come back to tree planting. Is it agriculture? Well, not yet it isn't, not in any statutory definition, unless it's ancillary to farming, so shelter belts, etc. So is it agriculture? No. Does it need planning consent? No. We have a look at Section 55 of the Town and Country Planning Act. No, it's not development, doesn't need planning consent. Bits of it might, the rides and pathways, etc. But does it need planning consent? No. So in that case, what does landlord have to do? He has to serve a general notice to quit, and that means that landlord basically has to make his case out and the tribunal can say, would a fair and reasonable landlord insist on possession? And if the tenant is there saying, well, actually, but I could, I could do that, I'm a farmer, I know how to plant trees, I can help with that, then that will all come into the mix.
George, do you want to come in on this as well, please?
Yeah, thanks, Robert. I mean, just to say that we have had a considerable amount of situations where our members who are on Agricultural Holdings Act tenancies have been threatened with case B notices to quit for tree planting, in our view, completely inappropriately, given what Julie has just said. And there's been some high-profile cases as well on that front. And I mean, as Julie said, on an FBT, it very much depends on what's in the contract. But within an AHA tenancy, the old-style tenancies, a general notice to quit can be used, and then there is whether or not the tribunal will consent to the landlord's notice. And what I would say is that I think it's vanishingly few cases where the tribunal has upheld the general notice to quit for tree planting. I mean, I can't remember the last time the tribunal did uphold a notice for tree planting. But it is something that sometimes we find some aggressive landlords and landlords agents using as a threat.
Oh, well, thank you, George, for that clarification. Julie, we have another question here from a member from Cornwall. My tenancy agreement contains a clause which allows the landlord to take back all or any of the holding for development within just 3 months. Is this legal?
So again, I mean, obviously we'd have a look at the detail, but basically, as I think we mentioned in the presentation, really, that there is a provision for short notice for non-agricultural use. If that's there in the tenancy agreement, then it is possible to serve a short notice for those purposes. So that might be the case. Yeah, that doesn't mean there's no objection can be made. That doesn't mean no application to the tribunal needs to be made, or no case B notice needs to be served with the opportunity to refer it to arbitration, etc. So it's not the end of the world.
And okay. Robert, I think this is really important that when we have people who are taking out tenancies or entering into tenancy agreements, that they understand the clauses that they are signing up to. Because quite often we see situations where people are so desperate and keen to get onto land, either as a new entrant or by expanding their operation, and they allow their heart to rule their head because they just get access to this land and think it's great, and then all of a sudden they find actually there's a short notice provision which allows the landlord to take the land back on 3 months' notice. So it is absolutely vitally important that people look at those agreements and make sure that they are fit for purpose for what it is they want to be doing. And many times I have conversations with members and advise them that there is a clause in the agreement which they might not like. And they say, well, that's fine. Now I know about it. At least I know about it. And to my mind, okay, you crack on that basis. But understanding and making sure that the tenancy agreement is fit for purpose is really important, because these short notice things can bite you in the backside.
Okay, well, thanks for that, George. There's a question here for you, a member from Kent. Will Rachel Reeves' new drive to reduce planning restrictions diminish the ability of tenant farmers to object to the land being lost to development?
Okay, well, I think this is one you're directing at me.
It is, absolutely.
I mean, obviously, it's early days for the new administration, and the new administration is beginning to unveil its plans, and it comes into that general thing that Julie was talking about in terms of the policy environment within which these things are operating. And it is true that the Labour government is looking particularly on the housing front, and wind energy. They are looking to see whether we can expand the amount of land coming forward for that. I still think, though, that the Labour government will be particularly cautious about wanting to do anything which unseats tenants. Our view is it's really important to ensure that no tenant is harmed in the furtherance of public policy to have house building and renewable energy. And equally, it doesn't get away from a piece of case law that there has been which is Regina versus the Vale of Glamorgan District Council, which says that the impact on the personal circumstances of a tenant farmer who is not the applicant for the development is a material consideration within the planning process. And we have seen local authorities turn down planning applications on the basis of the significant impact on the tenant farmer. So I think the answer to the question is yes, it will have an impact because it's part of the policy environment. But we would hope to convince, we would still hope to convince them that tenants shouldn't be adversely affected by that policy.
Okay, well, thanks for that. As you say, George, it is early days. We're only a few days into it, so let's wait and see. Julie, a question for you here, a member from Dorset. Can my landlord take back land to provide biodiversity net gain or nutrient neutrality for a developer?
So we sort of touched on bits of that in my sort of talk earlier. I think it first of all depends what type of tenancy you have. So easier, absolutely easier under a farm business tenancy. A farm business tenancy can have break clauses for. It doesn't have to be for non-agricultural use. It can be break clauses for specific things. So it depends whether it's farm business tenancy or not. It also depends whether it's a standard. I think it may influence whether it's a standalone. You know, this is what I'm going to do. I'm going to sell biodiversity units or nutrient neutrality credits. Or whether it is connected to a development, whether it's part of that. So if we're looking at the Agricultural Holdings Act and a general notice to quit to revert arable to pasture, I think it's going to be a difficult claim from the landlord for those purposes, because I've just used a word. I've just used arable to pasture, and pasture land, you know, that's within the definition of agriculture. So who does agriculture? The tenant does. So this is a perfect opportunity, actually. And I have worked on some of these. I'm pleased to say, if we look forward or look positively on this, worked on some of these where actually it becomes a landlord-tenant collaboration, so that you unlock things by the tenant doing what the tenant does, which is farming.
Oh, well, thank you for that. And as I say, it's the same with every webinar that we do. We always have more questions we have time to get answers for. So anybody who's put any live questions in tonight, or any of the questions that are on my pre-send-in list that we don't get a chance to do this evening, Julia says that she will answer the questions and we can put them back onto the website. So no one will be forgotten this evening, and because that's the last thing we want to do. But I know I'm very conscious of time. We have a question come up on the live chat here. Our 10-year FBT is ending in May 2026, so we are unable to challenge that. However, our landlord, the National Trust, is intending not to use the farmland for agriculture. They are going to be doing other things with the land. This is against the explicit documented wishes of the person who gave the farm to the Trust on his death in 2000. The National Trust says we are welcome to rent just the house from them post 2026, which is pointless as we won't be able to earn any income. Is there anything we can do to challenge this?
So, Robert, just to be clear, this is an issue that isn't just limited to this one question. We are seeing the National Trust taking this policy approach in other parts of the country as well. We have raised it with the National Trust as a concern, because what we believe the National Trust needs to be thinking about is how it takes a land sharing approach to deliver the cultural, the historic, the natural environment, natural capital outputs, and these corner solutions where they're taking land out of agriculture is not the right solution for these. And it wasn't so long ago that the National Trust found itself in grave difficulty when it tried to take land back in hand and manage it in hand. And they moved away from that policy, and I fear they're going to get themselves into that position again here. So we have asked for a meeting with Hilary McGrady, the Director General of the National Trust, and I will be meeting her in a few weeks' time to discuss concerns about this. So it is very much a live issue between us and the National Trust at the moment. But there's nothing you can do individually. You know, if the landlord takes the land back and wants to do something with it differently, there's no legal route to change that. I mean, obviously, there might be an issue here about what the beneficiaries, what the benefactors said that they wanted the land to be used for, and what covenants might be in place for that. But it is something we're looking at a policy level with the National Trust.
Okay, well, thank you for that. Well, I think that's an opportune moment to bring our webinar to a close this evening. I would like to thank Julie for a fantastic presentation and for George for coming in on our question answers. And I would like to thank our event sponsors, Boythorn Solicitors. We are taking a break over the summer months so that members can concentrate on their harvest. So we will be returning on the 25th of September, DEFRA scheme updates for farmers in England, and we will have Janet Hughes, the DEFRA programme coordinator. She will come and give us an update on the DEFRA farm schemes for England, and we will offer a live question answers as we have done this evening, and we just ask that people bear that in mind as we come to promote that event for your questions to come in. So hopefully you found this webinar very useful, and thank you for attending, and good night.